This is the 7th annual inclusion conference, focused on inclusion, and Jolly and Matt and everyone, Dale, do a fabulous job, and so I hope you all get a chance to thank them. It's a great conference. They do a wonderful job. And what I'm here to talk about today is the recent Supreme Court decision that was heard on March 22nd, or was decided on, heard on January 17th, decided March 22nd on special education, specifically on what constitutes a free, appropriate public education. This was a huge decision. It's the second decision by the U.S. Supreme Court ever in special ed, specifically on what a free, appropriate public education is. So it's going to have great implications for teachers and for administrators of special ed. And that's what I'm going to talk about today. So I'm going to introduce myself real briefly. My name is Mitchell. I'm from the University of South Carolina. Although my primary area is emotional behavioral disorders, most of my work and interest is in legal issues and special education. And so this is a real big deal. And the little background, I spent 16 years as a teacher in Minnesota. That's why I don't sound particularly Southern. And this is my 25th year at the University of South Carolina. Now, the decision Andrew F. v. Douglas County School District has a lot of implications that are really important for us. The number one implication, of course, is about what we as special educators do. That is, to provide an education that confers educational benefit or a free, appropriate public education on the children with whom we work. That's the our primary obligation, is to confer a FAPE. Now, free, appropriate public education has been defined in the law since I was teaching. In fact, in 1975, and some of you will remember PL 94-142, or the Education for All Handicapped Children Act, which was renamed the Individuals with Disabilities Education Act in 1990, first defined what a free, appropriate public education, or a FAPE, is. Now, the reason, there's a couple seats up here, in the table up here. The reason, of course, this is so important is, like I said, it's our major charge as special educators. Also, in special education, we tend to be the most litigated area in education, which means the most due process hearings, the most court cases of any area of education. In fact, we in special education account for 10 to 12% of all students in special education, yet special education, 10 or 12% of the students, account for 90% of all the litigation in all of education. And of all that litigation, 85 to 90% is on what exactly is this thing we call a FAPE. And the reason there's been so much litigation in this area is because of the way the federal law defines it. Now, both the idea, which of course is the federal law, and Article 7, which is the Indiana state law, essentially define a FAPE in the following way. It's special education and related services that are provided at public expense, meet the standards of the state educational agency, include preschool, elementary, or secondary education, and very important, are provided in conformity with the Individualized Education Program, or the IEP. Well, you see, that definition isn't really a model of clarity, and it's not very comprehensive. It essentially says what a child's FAPE is what we say it is in a child's IEP. Well, what happened immediately upon the law being passed is we started to see conflict between parents and between school districts about, well, what is this FAPE? What does that mean that we as school districts have to confer a FAPE? We have to write an IEP that confers FAPE. Well, when parents didn't agree with school districts and they couldn't come to a decision at the IEP table, essentially what the law does is it sets forth a series of due process procedures where parents can issue a complaint with the State Department of Education. Hey, Barb. With the State Department of Education. They can request a due process hearing. And after the due process hearing, they can go to court, state or federal court. 90% of the time they go to federal court, probably more than that, because IDEA is a federal law, and suits are usually filed under IDEA. And federal courts have their own structure, just like state courts. You start out with district courts. Every state has between 1 and 4 district courts, and then if there's an appeal from a district court, it goes to a circuit court, which is a large court of 12 judges that comprise an entire area of the country, and I'll talk more about that in a few minutes. And then there can be a final appeal to the Supreme Court of the United States. That is a really big deal when the Supreme Court hears something. Why? Because it's the law of the land. And they don't hear a lot of decisions. About 8,000 to 9,000 cases are appealed every year to the U.S. Supreme Court, and they may hear 90 out of 8,000. So when they hear a case, it's a big deal. They heard Endrew this past year. But in 1982, they actually heard the first case ever at the Supreme Court level called Board of Education v. Rowley. And to understand Endrew, it's important just to briefly talk about a couple of issues that were brought up in the Rowley case. First, it's important to understand that every case that goes to the due process hearing, a district court, a circuit court, or even the U.S. Court of Appeals, where does it begin? At the IEP table. It all starts at that meeting where we get together, parents and school districts collaborate to develop a child's IEP. That's where the Rowley case started. That's where the Endrew case started. So it's important to realize that the things we do, that is what forms the grist of these cases. Well, Amy Rowley was a very bright and, by all accounts, delightful little child, actually at an IQ of 145. How many of you are teachers, have children in your special ed programs with an IQ of 145? Not a lot. And that's been a criticism of the Rowley case because she was not a typical special ed student. Amy Rowley was gifted. She was profoundly hearing impaired. She was in fact deaf. What happened is the school district had, and this was way back in the initial era when PL 94 or EAHCA was first passed, that she went to a school called Furnace Woods Elementary. Her parents, who are also profoundly deaf, were quite excited by this new law because they had intended to send Amy to Fanning Hall, which is a school for the deaf and blind. And they were able to see in this law that, well, Amy could be educated with non-disabled students at Furnace Woods Elementary. So they contacted Furnace Woods Elementary, and the principal there was very excited to have Amy come into his school to be able to have a child with a disability in his school. And Amy went into kindergarten, and during the kindergarten year they had a meeting where they said, well, what we propose is we're going to develop an individualized education program for Amy, and what we're going to do in this IEP is we're going to talk about what she needs to be successful at Furnace Woods Elementary. And so they got together and they collaborated and they came up with a really good IEP that included speech and language services, it included tutoring, and they did some technology, a thing called a teletypewriter in her home and in the school. She was given, some of you may remember, the big old phonic ear that the teachers used to have to wear. And the parents were very happy with that. The school was very happy with that. However, the parents also said, you know, she's profoundly deaf. Amy is a great lip reader, but we're worried that as she goes through her school career, she's not going to get all the information she needs, because even the best lip reader maybe gets 70% of what is said, maybe. And so they said, we would like a sign language interpreter. And the school district initially said, we don't see a problem with that, but we're going to consult with our administrators. They went back to the administrators, and in fact, the school district attorney it was called the Hendrick Hudson School District, had said, well, no, you know, we should hold off on that. Why don't I suggest you do an experiment? You know, having a sign language interpreter for a few weeks. So the principal decided, we will bring in a sign language interpreter for Amy's 3 of her last 4 weeks as a kindergarten student and just kind of see how it all works out. Well, they brought in a young man who stood next to the teacher and signed everything. And after a week, he went to the principal and he said, this experiment isn't working. Amy is very embarrassed that I'm there because she knows that why I'm there is just for her. All the other kids are pretty interested in me. Amy won't even look at me, so it's just not working. Principal said, okay. They had an IEP meeting for Amy for first grade, and they had all those aspects of the IEP they had before, the teletypewriter, the phonic ear, the speech and language speech and language clinician. But when they got to the sign language interpreter, the school decided not to provide those services. Well, the parents disagreed with that. Well, the school district, and you know, there are times when parents and school districts can't collaborate or get together on a certain aspect of a child's education. Well, Amy went ahead into first grade without a sign language interpreter. Parents called, requested, as their right was, to a due process hearing. And in the due process hearing, the hearing officer basically didn't have a lot to go on. There was no, see what a hearing officer, and I should back up. I am a hearing officer in South Carolina, a state hearing officer, and what we have to do is we listen to testimony, and then we look at the law and compare the two. We compare the facts of the case as we determined through the testimony with the law and try and match them up. See, well, did the school follow the law? Well, in this case, the poor hearing officer had nothing from other courts to guide his decision. So he decided what FAPE means is that a child has to receive a beneficial education, but not the best education. And so he decided in favor of the Hendrick Hudson School District. Parents appealed to the district court for the Northern District of New York, and they overturned the hearing officer because the way they interpreted ideas, they said the idea, then the Education for All Handicapped Children Act, requires that FAPE provide equal opportunity for disabled and non-disabled students. Equal opportunity, which means, in the eyes of the district court, that the education provided to youngsters with disabilities should allow them to achieve to their maximum potential. The case then was appealed by the school district to the U.S. Court of Appeals for the Second Circuit, who upheld the lower circuit, saying, Education for All Handicapped Children Act is about equal opportunity. It's about giving Amy a chance to achieve to her maximum potential. School district lost. They appealed, final appeal, to the United States Supreme Court, which I said, they do not hear many cases. They decided to hear this for a number of reasons. One, it was the first case ever heard on an important federal law, and two, because just some circuits throughout the United States kind of had different opinions about what this thing FAPE means. So the Supreme Court decided we need to define what a free, appropriate public education is. Well, so they took the case, and the Supreme Court, they don't hear a whole case again. What they do is they answer a specific question. And they looked at two specific questions. One is, what exactly is a FAPE? And two, how are courts to be involved in determining what a FAPE is? Well, the first thing they did is they read the Education for All Handicapped Children Act, and they considered the parents' attorney's argument that the school district was required to provide an equal educational opportunity that allowed Amy to achieve to her maximum extent potential. And what the court said is this: the requirement that states provide equal educational opportunities would seem to present an entirely unworkable standard requiring impossible measurements and comparisons to require the furnishing of every special ed service that would allow the handicapped, or as we now say, child with the disabilities to achieve to their maximum potential. In other words, the Supreme Court said, that's a bridge too far. That's not what we think Congress has required. This is what we think Congress has required. We think that Congress requires that schools provide a basic floor of opportunity, which consists of specialized instruction, related services which are individually designed to provide, and this is an important one, educational benefit to the handicapped child. Now, what the Supreme Court did, and this becomes very important in every subsequent case, every FAPE case I ever heard as a hearing officer, and any case ever any court has heard about FAPE, has to answer this two-part question that the Rowley, the Supreme Court proposed. They said, number one, in any FAPE case, a hearing officer, a judge, a court of appeals has to ask themselves two questions. Number one is, has the state complied with the procedures of the law? And of course, as special educators, we know we have got a lot of procedures, right, that we have to follow. We have to have we have to get notice. We have to notify parents in time to be at the IEP meeting. We have to meet. We have to collaborate with parents at the IEP meeting. We have to have the proper membership on the IEP team. We have to have all those components of the IEP. So these are procedural things. Number one, the court said, first thing a court has to do is they have to determine, did the school district comply with the procedures of the law? So in other words, did they do all those things the law requires? Well, they looked at Furnace Woods Elementary School and they said, you know, they did a great job. They followed all the procedures to a T, no problem there. We hold that in the first part of the test, the school district prevailed. Then they turned to the second or more difficult part of the test, which has been called the substantive part of the test. Is the resulting IEP that was written for Amy or any other special ed student reasonably calculated to enable the student to receive educational benefit? That's the crux of the second test. Did the child benefit educationally? Well, let's think about Amy for a second. Gifted, 145 IQ, very bright child, the top of her class academically. So what did the court do? They looked at her report card essentially and they said, hey, she seems to be doing very well. She's passing from grade to grade. And so clearly, Amy did receive educational benefit. Now, they also said, and often been ignored, they also said, but we're only talking about Amy here. Passing from grade to grade, that works for Amy. It's not going to work for all children. So you still have to make an individualized decision. Nonetheless, this became an area that led to a lot of litigation. This part is not too difficult. For a court to determine, did you follow the procedures? They just looked at the procedures, they looked what you did, and they matched the sample. They say, yep, they did that. Okay, well, because Furnace Woods had done a good job, so they followed the procedures. When they looked at the second part, IEP reasonably calculated, well, again, because Amy was so bright, they decided she passed from grade to grade. Yes, Hendrick Hudson prevailed. So the school district prevailed in this case, but immediately it led to a lot more decisions. One of the reasons is because Amy was not your typical special ed child. And so what happens when you have a child with a severe intellectual disability or with severe orthopedic impairments? How do you determine if a child has benefited educationally? Well, what happened in the next 20 years is we had court cases all over the country grappling with this very question. What is educational benefit? Now, You're in the Seventh Circuit in Indiana. So, and this is a geographic map of all the courts in the United States, and you see I'm in South Carolina, way down here in the Fourth Circuit. Well, if you look at this map, we had a number of, actually 6 circuit courts in the United States that interpreted FAPE using a very low standard. In other words, when they did the Rowley test, that was still there, but when they got to that part, they said, well, what educational benefit means for a child with disabilities is a little more than nothing. What the courts had called de minimis education, which means trivial. So if you provide an education that confers a little benefit, you're meeting the Rowley test. You are providing a FAPE. However, notice Seventh Circuit didn't actually have a decision, but there's lower standards in the 8th Circuit, the 10th Circuit, the 4th Circuit, the 2nd, and the 11th. So they were saying educational benefits means a little bit of educational benefit, just a little bit. Now there are other circuits like the 3rd, 6th, and to some extent the 5th, were saying, oh, no. Congress would have wanted more than just a little bit of an education. They want meaningful benefit. That was a higher standard. And then we had one circuit where actually a circuit is comprised of 12 judges, usually 3 hear a case, and they divide them up. They had some panels in the 9th Circuit having a high standard and others having a low standard. So it's kind of a confused circuit. But this is the deal. Whenever you get disagreements between the circuit courts, it makes it much more likely that the Supreme Court is going to step in and try to settle the dispute. And that happened in a particular case out of Colorado, which was a low standard circuit called Endrew v. Douglas County School District. This was heard by the 10th Circuit in 2004. Well, it was an interesting case, but involved a young child with autism who was relatively severely disabled. He was diagnosed with autism and ADHD when he was 2 years old, attended the Douglas County public school system from preschool all the way to grade 4. When he got to grade 4, the parents said, you know, Drew has been doing really well, but his progress stopped last year. He is not academically, his progress has stalled. Behaviorally, he's getting worse, and the behaviors aren't getting under control. We don't believe at this point your IEP confers a FAPE. Because look at these IEPs. The 3rd and 4th grade IEP had the same goals. The goals didn't change, which indicates to us that the child made no progress. And so what happened is the parents, when the school district decided not to change the IEP as the way they wanted, to include, among other things, a behavior intervention plan, they took Drew and enrolled him at a private school for youngsters with autism in Denver, Colorado, called the Firefly Autism House. And Drew was educated there for a couple years, well, a number of years, but after 1 year, he was doing much better academically, and behaviorally, his behaviors had really gotten under control. So the parents went back to the school district, and they said, we want Drew to be in the public school, so we would like to do his 5th grade IEP and look at some of those things that they did at Firefly that made him successful. One thing they did is they had new academic goals that really required a lot more learning on his part. They had a behavior intervention plan that was crafted by behavioral experts that really got his behavior under control, and we would like you to do this too. And the school district countered with an IEP that had the same goals as the 4th grade IEP and had virtually a non-existent behavior intervention plan. So the parents said, this doesn't work for us. We want tuition reimbursement. Because one thing parents can do is if they believe that a school district is failing to provide a FAPE, they can pull their child out and put the child in a private school and later sue for tuition reimbursement. That happened in South Carolina, actually, in a case called Carter v. Florence, where they pulled their child out to a private school and then sued for tuition reimbursement. When it went to court, the judge has to determine two things. One, did the school district fail to provide a FAPE, which they used the Rowley test? And two, did the school district or the private school offer a good education? In the Carter case, the answer was yes. School district to both, or no and yes. They believed the school district had not provided FAPE, according to the court, and that the Trident Academy in Charleston had provided a FAPE, so they ordered tuition reimbursement. They also ordered attorney's fees, because the idea requires that a prevailing party may be awarded attorney's fees. Well, in the Carter case, the parents got $36,000 for placing their child at Trident Academy for 3 years. Well, that was, in the late 70s, so it's a lot more, and private schools are a lot more than that now. And they got a lot of tuition or attorney's fees too, because they sued for attorney's fees to take the case from the district court all the way to the Supreme Court. Well, in the end, the Florence County 4 wound up paying $36,000 in tuition reimbursement, $1.5 million in attorney's fees. And so that's a pretty big issue. Well, that's what they sued for. Tuition and related expenses, which means attorney's fees. Well, it went to a hearing officer. And the parents contended the school district had denied Drew a FAPE because the IEPs changed the same from every year. He was not gaining in math or reading, and his problem behaviors were out of control. And additionally, they said not only did the school not provide FAPE, but Firefly Academy did a great job because academically he's doing much better in terms of the behavior. It was very much brought under control. But, so the hearing officer took this case, and he looked at the facts of the case, and it's undisputed the goals were the same from year to year, and it was undisputed that Drew did not do very well behaviorally, and there was not much of a behavior intervention plan. It was undisputed that Firefly had done a great job with Drew. However, the 10th Circuit, as you remember, is a low standard circuit. They use a very low standard in determining what a FAPE consists of. And so the administrative law judge, using this lower standard, said, well, in the first part of the Rowley test, the Douglas County School District has done a great job in following the procedures of the law. Now I'm going to look at, did Drew receive an appropriate education? And he looked and he said, well, back in 2nd grade he did okay. He didn't do very well in 3rd grade. He did even worse in 4th grade. But there is some indication that he got a little benefit at one point in his education. Therefore, I apply the lower de minimis standard and hold that the school district prevailed. Well, the parents, not very pleased with that decision, appealed to the United States District Court for the Northern Circuit in Colorado, and the district court upheld the hearing officer. Because again, they have to use a low standard. You have to use a standard that your circuit court says. And so the parents filed an appeal with the U.S. Court of Appeals, who agreed with the district court. They lost at all 3 levels. Due process hearing, district court, and circuit court that said Douglas County School District had provided a FAPE, and because they had this low standard, they said didn't have to do much, but they did provide FAPE, therefore we don't even have to say did Firefly Autism House do a good job because the school district provided FAPE. Well, what happened at the 10th Circuit, like I said, is they noted 2 conditions. They only had to really address the one. Did the school district provide FAPE? And they used this low standard. In fact, a term a particularly kind of an obnoxious terminology used in the 10th Circuit Court of Appeals decision in Endrew was, the educational benefit mandated by the idea must merely be more than de minimis. In other words, it's just a little more than nothing satisfies the lower standard. And of course, this terminology was actually written by a judge on the 10th Circuit by the name of Neil Gorsuch, who is now in the Supreme Court. Merely more than de minimis. Well, the parents were quite upset with this. They were undaunted, though. They were going to try and exercise appeal, which they did to the United States Supreme Court on December 22nd, 2015. Remember, they only ask a question. They don't have the Supreme Court won't hear the whole case. They just will hear a question. Here was the question. What is the level of educational benefit school districts must confer on children with disabilities to provide them with a free, appropriate public education? In other words, what is the second part of the Rowley test? What does educational benefit mean? Well, certiorari was granted on September 29, 2016, which means the Supreme Court, out of 8,000 cases that appealed that year, decided, we're going to hear this case. We're going to answer this question. Partially because there's a difference. The district courts, circuit courts are interpreting that standard, that second part of the Rowley test, in a low way and in a very high way. So what is the difference? We as the Supreme Court are going to have to answer this question. And on January 11th, 2017, a Supreme Court comprised of 8 justices, Neil Gorsuch had not yet been approved for the Supreme Court, heard this case. Extremely momentous decision because they were going to have to answer, what does the second part of the Rowley test mean? What is educational benefit? But this time, instead of a gifted child, they had to answer this question about a child who is very severely disabled. So they had to really grapple with this question. We had a 4-4 court at that point. These are the usually considered the more liberal. These are more conservative justices. Now, for those of us who watch the court a lot, we thought, well, this could be unfortunate because if it comes out to 4-4 tie, it's like the decision never happened. It goes back to whatever the circuit court held. Well, I happened to have to be in Washington on the 12th and 13th, so I quickly called up Delta, changed my airline to get there 2 days before. So I got there on January 10th, found a hotel very close to the Supreme Court, and decided I'm going to try and hear this decision. It's a very important decision to all special educators. But the thing about going to hear a Supreme Court case, and if you ever get a chance, it's a really great experience. Right where this Supreme Court emblem is here, where Justice Breyer's tie is, there's a line that starts where if you want to get in the Supreme Court, you have to get in line. And they don't take reservations. You just have to be in line. There have been cases in which people have camped out for 2 days to get into a Supreme Court case. Well, I thought, you know, this is an important case for us, but we're not that many special educators, so I thought, you know, the Supreme Court opens at 10 o'clock. If I get there by 5 o'clock, 5 hours early, I think I'll be okay. So I got up and got dressed, ran to the line here, and waited in 32-degree temperatures, because it was a cold day in Washington, until 9:45 where they let you in. And lo and behold, I did get in to the Supreme Court. This is me, and you can't see it, but it says 3. I was the third one in. These are 2 people, friends of mine, Deb Ziegler and Katie Grady, who are from CEC. They were 1 and 2. And then another friend of mine who didn't get there till 5:30, still got in, winding up being 26 or something. But the interesting thing is, when I got in line at 5 o'clock that morning and was sitting there shivering, the 2 guys in front of me were men waiting. And so we got in, we talked a little, and when we got in, I thought, well, I'd see him, but I didn't see him anymore. Why? Because I didn't know this about Washington, D.C. There are professional line standers. There were people that'll stand in line for you for $40 an hour. And they were there at 5 o'clock before me, so they stood in line. Now, I don't know about Indianapolis, but in Columbia, South Carolina, we don't have many line standers. So I didn't even know about it, but I wouldn't have done it anyway. But I got in to hear the case, and it was very fascinating. If you ever go to D.C., just go to the Supreme Court, just to go down to the basement and look at their kind of museum. It's fascinating. But so we listened to this argument, and we tried. I don't know if anybody's ever heard an NPR, Nina Totenberg. She's their special ed, or she's their Supreme Court. She's always trying to glean what they might decide based on their questions. Well, that's kind of what we did. And David and I are both really legal nerds, so we listened to the judges, and we thought, when we got out, we were very interested. But Kagan and Ruth Bader Ginsburg, who I didn't know, but in the court they call her notorious RGB, both were very clearly in favor of a higher standard. They wanted what Justice Ginsburg called a standard with a bite, which indicated to us, well, these two, who we thought were going to be for a higher standard, they're going to be for a higher standard. We knew that. And then Justice Breyer and Justice Roberts, at one point Justice Roberts said in the court, and this is what passes for Supreme Court humor. He pointed to the Douglas County School District and said, you want some benefit. And then he pointed to the other side and he said, but you want some benefit, putting an emphasis on. People laugh. That's Supreme Court humor. But essentially what he was saying is, you want a little bit of benefit, you want more benefit, but where in the idea does it say anything about minimal benefit? And Justice Breyer over and over kept saying, why does the idea talk about progress when you, school district, are saying little bit of benefit is okay? How does that work out? And then finally, Justice Sotomayor, who always kind of seems to sort of just puts really good spin on it, because she talks in ways that are a little more understandable. She said, IDEA provides a clear standard. There is a clear standard in the IDEA. And it's a lot more than de minimis benefit, but we've just got to come up with the right words to be able to tell lower courts and hearing officers what exactly is this higher standard I believe IDEA requires. Well, we thought the Supreme Court will announce the decision in May. Well, they didn't. They announced it on March 22nd, which was kind of a surprise. Justice Roberts wrote the decision. He's a good writer, very interesting decision, and I'll show you how to get to it in a few minutes. It's really excellent reading. But one of the things he said right off the bat in the decision is this. He said, in Rowley, we gave the two-part test, but we declined to really endorse any one standard to determine when a child is receiving educational benefit. But that more difficult problem is before us today. So in other words, he recognized right away in the decision that, well, we've got to really now, this Supreme Court has to answer this question. What is educational benefit? And in their decision, this is what a unanimous Supreme Court held. They rejected the merely more than de minimis standard, vacated the decision, and remanded the case back to the 10th Circuit. In other words, and I'll talk more about some of the specific things they said, but they said the law requires more than de minimis benefit. It requires meaningful benefit, but that in itself doesn't mean much. So what the decision was really about was trying to define what is the standard more than de minimis. Clearly, de minimis is dead. And what they said by remanding this decision is your decision. It's going to go back to you, 10th Circuit, with this new standard that we've developed, not the Rowley standard, not your lower de minimis standard. We're using a new higher standard. Now you got to redecide this case. And so it's remanded to the 10th Circuit. And here's the standard. The new standard that the Supreme Court came up with is this. To meet its substantive obligation under the IDEA, a school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. Now, progress appropriate is the kind of the operative phrase here. That is much more substantive, according to the court, than meaningful benefit. Meaningful benefit meant all these things to different circuits, but progress implies more forward movement, that a child is actually progressing from where they were. So there's a certain kind of, David and I wrote an article that just was in Teaching Exceptional Children. We think there's 5 major takeaways that we as special educators need to understand about this decision. Number 1 is the Supreme Court has rejected the de minimis standard. There is no more trivial educational benefit. That is gone and dead, buried forever by a unanimous Supreme Court. So what this kind of de minimis standard, which the Solicitor General called a little bit more than nothing satisfying the meaningful benefit standard, is gone. It has to be more than that now. In fact, the Supreme Court said that a student offered an educational program that provides merely more than de minimis progress from year to year can hardly be said to have been offered an education at all. Pretty strong language. A substantive standard not focused on student progress would do little to remedy the pervasive and tragic academic stagnation that prompted Congress to act in the first place. In other words, when Congress passed this law back in 1975, they were not thinking about just a little bit of education. When they reauthorized it in 1990, 1997, 2004, they were focusing on student progress. And if they hadn't focused on student progress, according to Justice Roberts, they wouldn't have been able to remedy the problems that were with us before the law was passed. So clearly, de minimis standard is gone. Courts will no longer use that standard. Now, a second important thing is the Supreme Court also rejected the maximizing standard, because Drew's parents wanted essentially the same thing Amy wanted. They wanted an education that allowed Amy to achieve to her maximum potential. The Supreme Court did reject that. They did say that, well, no court can, how can educators determine if we're providing an education that allows a child to benefit to their maximum potential? That's going too far. But it's a lot more than de minimis. So kind of what the Supreme Court did is sort of cut the middle ground in favor of progress, but it's still not maximization. Third major takeaway is the Endrew F. decision does not replace or overturn the Rowley decision, rather it clarified it. It clarified the second prong of the Rowley test. So Supreme Court kind of took the unusual step of actually denigrating their previous decision in Rowley. They said, we find little significance in the court's language in Rowley concerning the requirement that states provide instruction calculated to confer some educational benefit, because circuit courts were interpreting it in so many ways. And so what they said is they developed this new standard. So essentially now, what every hearing officer, what every court has to do in a FAPE case is they have to use what we could call the Rowley-Endrew test. And that is, number one, same as before. In the development of an IEP, has the school agency complied with the procedures set forth in IDEA? But number two, is the IEP developed through the IDEA's procedures reasonably calculated to enable the child to make progress appropriate in light of his or her circumstances? So this is the Endrew contribution. It does away with meaningful benefit. It says make progress. Now, one of the things that is interesting, we were talking about this before we got together here, is the full implication of the decision is not going to be really clear until other courts rule on this, because every hearing officer, every state, every district court judge, circuit court judge now has to use the Rowley-Endrew test in determining if your IEP is reasonably calculated to provide FAPE. And we're not going to be really certain about what exactly that means until we see more court cases. But what I think we can clearly say is this is a lot more rigorous than the standard we operated under prior to the Endrew decision. What does it mean in the long run? I think it means that all kids with disabilities, mild and more severely disabled youngsters, school districts were going to be held to a higher standard in writing our IEPs. And I'll talk more about that in a minute, and a lot more about that tomorrow. But what it probably also means is we're going to see a lot more lawsuits, I think. And if you can say any one thing, it's this, that this decision is going to change the life of attorneys who represent school districts. Because, see, they used to be able in the court to say, well, you know, back in second grade, Drew got a little progress, so that's okay. They can't say that anymore. So, because that old de minimis standard is dead. Now, the 10th Circuit, remember, had to hear this decision again. It went back to the 10th Circuit. And what did they do? On August 2nd, they kicked it back to the district court. They said, they essentially said, we therefore vacate our prior opinion. In other words, it's wrong. We're vacating it, and we remand it to the United States District Court for the District of Colorado for further proceedings in light of the Supreme Court's decision in Endrew. In other words, now the District Court has to rehear it using this new standard. Well, there is almost no, you can bet the farm that they're going to overturn the Endrew decision. Why? Because the Supreme Court said it's wrong. You didn't do a very good job, now redo it. So this decision is almost certainly going to be overturned. And almost certainly Endrew's parents are going to go and sue for tuition reimbursement, which is, I think it was like $60,000 a year. And they're going to sue for $70,000 a year. And they're going to sue for attorney's fees, which I would say is probably $3 or $4 million. So there's the Denver County School District is going to be paying dearly for this. Also, one of the things, another thing that Justice Roberts said that I think is really important is we're not putting a standard on judges here. We're doing a standard, not a formula. We're not saying this is what an appropriate education looks like for every child. We're saying this is the standard you have to measure an appropriate education by. And again, the adequacy of an IEP turns on the unique circumstances for the child for whom it was created. The role of the courts is, and this is an important one, a reviewing court may fairly expect those authorities to be able to offer cogent and responsive explanation for their decisions that shows the IEP is reasonably calculated to enable the student to receive progress. In other words, before a due process hearing officer, for a court, that is a question that will be posed by a hearing officer to a special ed director. What is your explanation? Why do you believe this is going to lead to progress? And how are they going to reply? That's a hugely important issue. And you know, although we're going to talk about it more tomorrow than we can today with the time we have left, clearly it's going to require the things that the IEP Resource Center has been talking about for years. Measurable annual goals, data collected to show progress, These are very important issues, and they will be at the forefront of FAPE cases in the future. Fifth major takeaway we had from this is it provides a lot of guidance to us as special ed teachers, ed administrators, on how we can develop IEPs that meet the Endrew standard. Just a couple quotes from the decision. A focus on the particular child is at the core of the idea. The instruction offered must be specially designed to meet a child's unique needs through an individualized education program. Not a lot of difference there. Here's the difference though. An IEP is constructed only after consideration of the child's present levels of performance, disability, and potential for growth. That has never been in any decision I've ever read before. The words potential for growth. In other words, it means we as IEP team members have to consider at the beginning, if we have to, in our present levels, what is the child's potential for growth? And that's what we have to address in the IEP, because Justice Roberts went on to say we need to develop challenging goals based on the child's unique circumstances that confer academic and if necessary, functional progress. Now, the U.S. Department of Education thought that this decision is so important that they took somewhat an unusual step on December 7th to issue a document. And I'm sure some of you are familiar with this, called the question and answer document on the Endrew decision. And essentially what the Department of Education did is posed and answered 20 questions, including 5 questions on what does that mean for us as IEP teams. Now, I could give you a long URL, but the best thing is go into Google, put U.S. Department of Education Endrew decision, and you will be taken to a couple sites, one of which is called the PDF on questions answered. That is the actual document that they issued. Download it, read it. It's an extremely useful document in interpreting how the U.S. Department of Education's take on the importance of this decision. And they do believe it has a lot of implications. We go to 1:15, am I correct? 1:45? Yes. Oh, good, I have a lot more time then. Okay, well, great. I'm going to talk about some of the recommendations that I think this has for us as IEP team members. Number one, we need to continue to train all our IEP team members to avoid procedural violations. Because remember, the procedures are still the number one part of the Rowley test. Remember, procedures are the things like having all your IEP team members there, having the parents meaningfully collaborate in the special education process, having all those elements in the IEP, all those things that Article 7, all those things that the idea says that we need to do. We need to make certain that they're done correctly, because in and of themselves, a procedural mistake can lead to a denial of FAPE. If you make a procedural error, here's the deal. If you make a procedural error and later on a hearing officer decides that that somehow affected the child's education or the parent's ability to be meaningfully involved, that procedural error by itself means the school district loses. They don't even look at did the child benefit? Because if you make a procedural error that caused the child or the parent not to be involved, you lose. It's that simple. So it's very important that all IEP team members understand that you have to follow these procedures. And the major procedure is this, that we have to ensure that parents are meaningfully involved in IEP meetings and that their opinions are considered in establishing the child's educational and behavioral goals. The Supreme Court in Rowley and again in Endrew, really emphasize the importance of collaboration with a student's parents. And in fact, that's kind of the hanging offense in terms of procedures in the idea. And that is the ultimate procedural safeguard. If a court thinks that you've done something that did not allow the parent to collaborate fully, you're going to lose. The school district will lose. And an acquaintance of mine, Perry Zirkel, talks about the spaghetti strategy that attorneys use. Any attorneys in the room by any chance? Okay, well, you can't agree then or disagree. But what Perry says, and this is true, as a hearing officer, I can tell you this is true. One of the things hearing attorneys for parents will do is they will take everything they can and throw it against the wall and see what sticks. And if they throw up that the parent was not involved, that will stick. If the school district, if a court believes or a hearing officer believes you did not involve parents, you will simply lose. So it's very important that we collaborate in a meaningful way with parents. And of course, I just found out that our Department of Education, Indiana, is the only Department of Education in the country, I think, that has a parent training representative on staff. What that is, every state must have what's called a Parent Training Information Center or Resource Center. They all call them different names. But you actually have one in staff. So that's a really important thing, that we understand how important collaboration is with the students' parents. And one of the things, one of the number one ways that courts get convinced that parents who are not allowed to collaborate is what the courts call predetermination. If they find out or have an inclination, believe that you somehow predetermined a child's program or their placement without the parents involved, that is cutting out the parent from the decision. That's almost an automatic loss for a school district. So predetermination, really be careful of that. Now that doesn't mean that school district personnel can't meet before an IEP meeting and talk about issues. What it means is you can't make a final decision without the parents' involvement. So that's really important to understand. Just a couple of items from Endrew on parental participation that I picked out because I think they're important to understand, because they present the Supreme Court's reasoning about parental participation. And they said an IEP must be drafted in compliance with a detailed set of procedures that emphasize collaboration among parents and educators and require careful consideration of a child's individualized circumstances. In other words, parents involved at every step of the process, from assessment to developing the IEP. And there has to be collaboration. And the Supreme Court, Justice Roberts, called IEP development this fact-intensive exercise. Will be informed not only by the expertise of school officials, but also by the input of a child's parents. And I already told you this one. But judicial deference to school authorities will depend on their having provided parents in the IEP process with an opportunity to fully air their opinion on the child's requisite degree of progress. So again, have the parent involved. And if, you know, as a public school teacher for 16 years, I can tell you, I was at IEP meetings where parents really weren't involved because it was kind of an intimidating situation. You've got to make the parent comfortable. You've got to make them understand that what you're going to say is very important. We're going to consider it. Now, we may not agree with it, and that's okay, but you have to consider it. You have to give it meaningful and thoughtful consideration. Third major recommendation is when developing the content of the IEP, of a student's IEP, and subsequently reviewing it and revising it, be sure that the present levels of performance and annual goals are based on evaluations and other relevant data that are current. We have to, our present, what is the foundation of our IEPs is the present levels of academic achievement and functional performance that we write. And of course, many of you know in IDEA, when it was reauthorized in 2004, they changed present levels of performance to what used to be called PLOPs or PLEPs, to present levels of academic achievement and functional performance, emphasizing the importance of addressing not only academics, but functional needs, communication needs, behavioral needs, whatever they may be. And that we have to have the parent involved and ask them, what is your child's important needs? And consider those in developing the IEP. And that the present level statement, because it's the foundation of the IEP, it has to be thorough. They have to address all of a child's needs, and they have to do so in a way that informs us about what's going to come after. I mean, what do the goals and objectives look like? Because remember, IDEA, or Justice Roberts used the term, in light of the child's circumstances and potential for growth. So when we do our present level statements, we have to be addressing those important issues. What is the child's potential for growth? What has worked with a child in the past? What does a child need to access the general ed curriculum? And by the way, the U.S. Department of Education, I know Matt and I have discussed this before, issued what is called a Dear Colleague letter a couple of years ago, talking about the general education curriculum vis-a-vis a child's goals. One of the major statements they made is that in writing the goals, we have to be informed about what the general ed curriculum requires. But still, the goals have to be individualized. The important thing is individualization, that they meet a child's needs. Now, that leads us to, and this, we cannot overemphasize how important the assessment and the present levels of achievement are, because courts have said that's the basis of a child's IEP. And if that is done incorrectly, what do you suppose happens to the rest of the IEP? Falls. In fact, there was a court in Ohio a number of years ago who used the analogy of a house. It said the IEP is like a house. The foundation of the house is the present levels of performance. If that's wrong, probably nothing else in the house is going to stand. So really, we need to emphasize to our IEP teams how important it is the assessment process is relevant and gives us information about a child's potential for growth and what we have to address in our special services, in our IEP. Now, recommendation 4 then is that we must ensure that annual IEP goals are challenging, appropriately ambitious, and measurable. And that's I've highlighted those because they're very important. In the Supreme Court decision, Justice Roberts wrote that one of the things in the Rowley case is that we know that Amy was a gifted child, and she was doing fine moving from grade to grade, but Drew was not. Endrew was not. He was not able to pass from grade to grade, so that wasn't an appropriate standard for him. So we, nonetheless, and this is a direct quote from the Supreme Court, the goals may differ, but nonetheless, all children have to have an opportunity to meet challenging goals and objectives. That we want our goals to be written in a way that allow children to make progress appropriate in light of his or her circumstances. That is, all IEPs must be measured against that standard? Will it allow the child to progress? Now, that means we need to have challenging and appropriately ambitious goals. What are appropriately ambitious goals? Let me go back to the case out of South Carolina called Carter v. Florence that actually went to the Supreme Court. This was in the mid-'80s. But when it was heard in South Carolina at the district court level, it was a FAPE case. Actually, when it went to the Supreme Court, it was no longer about FAPE. It was attorneys. It was about reimbursement of tuition and things like that. But at its in the initial cases, it was about FAPE because Shannon Carter was a young girl who had a mild disability. She was actually severely learning disabled and could not read. She went to a high school in Florence County 4, in a fairly large high school now, called Timminsville High School. And she went into 9th grade, and her IEP was written. And the goals the IEP team wrote for Shannon, now Shannon was going into 9th grade. She read on a 4th grade level. And what the goals called for, actually she read on a 3.6 grade level as measured by the Woodcock-Johnson. What the goals said, in 1 year's time, Shannon will gain a fourth of a year. She will go from 4.0 or 3.6 to 4.0 in 1 year's time. And they said the same in math. Well, the court looked at that and they said, well, Shannon is down here. Her peers are up here. Her peers are growing like this. And your ambitious goal is going to require she goes like this. She's going to keep losing ground. And so the term that the court used is the IEP goals were inadequate from inception. That the moment they were written with so unambitious, they resulted in an IEP that did not confer FAPE. Why? Because the goals were not ambitious enough. Now that doesn't mean that they should have said Shannon will be reading in 12th grade by the end of 1 year, because clearly that was unreasonable. But to say she only makes a little bit of growth in a year, and that was under the Rowley standard. Under the Endrew standard, it's going to be a lot more than that. So it's important that we write goals that are ambitious for children. And I always hear this in talking with, especially IEP, with teachers. They're worried that if we write goals that are too ambitious, we may lose when you get to court. Let me tell you this, never, ever, ever has a FAPE decision gone down against a school district because their goals were too ambitious. It's always because the goals are not ambitious enough. And so you don't need to worry about that, because remember what the Supreme Court told us? What is the child's potential for growth? Write challenging and ambitious goals that, if the child makes them, results in actual progress. Now remember, the IEP is not a guarantee of success. No court has ever said, you didn't meet the goals, therefore you lose. But many courts have said the goals were not ambitious enough. So yeah, you lose, because if the child met them, it's sort of like, so what? So we have to make certain that goals are challenging and appropriately ambitious. And if they're not measurable, and I know Matt and folks are always talking about making goals measurable. If they're not measurable, you can't show progress. If you can't show progress, the Supreme Court now says that you're not providing a FAPE. And one of the things I'll talk about tomorrow is also, when we do our IEPs, we do them from a prospective standard. In other words, we're trying to see into the future, 1 year's time, in writing those goals. We want to just make certain that we write those goals, they're ambitious, the child meets those goals, they've actually made some progress, and we want to make sure we can actually measure them. Because you can bet in the future, if you're in a due process hearing, and they ask you, like the Supreme Court says, why do you think that allowed the child to make progress? What do you suppose the response is going to look like is if if you can't measure progress? Well, I don't know. It says that the child will improve. Well, what does that mean? That doesn't mean anything. You have to show progress. You have to have measurable annual goals. So that's very important. The goals have to be ambitious. They have to be measurable. And remember, progress appropriate in light of the child's circumstances. So we're not making goals for every child. We're making goals for an individual child. Okay? So I've seen many IEPs in my time, and especially for mildly disabled children. Schools have taken standards off their state standards, and they write those in as goals. They're absolutely inappropriate, because maybe those standards are important things you're aiming at, but this is about the child's individual circumstances. The goals have to be crafted to the child's individual circumstances. Recommendation 5, continuously monitor and measure a child's progress on annual goals and objectives and benchmarks if applicable, and maintain specific data to demonstrate that progress has been made. One of the things I noticed in looking through the brochure, I believe in a couple months, or a couple weeks, I think, Matt, you're having doing something on collecting data. That is so important now, because you cannot show progress unless you have data. You cannot show that the IEP was crafted to enable a child to progress if you didn't have any way to measure it. That's why you need the measurable goals. But we also have to continually monitor and measure a child's progress toward their annual goals. So we write our annual goals that are ambitious and challenging, and then we measure a child's progress toward those goals. Now, if the child is not progressing, what does that mean? Well, we have to make instructional changes and maintain data collection to show us if progress is being made. Remember, courts don't require that a child achieves the goals. It requires that we make good faith efforts. Though we write goals that if a child achieves them, they're going to make progress, and that we monitor and measure. So very important. Remember, data collection using progress monitoring is absolutely important, which of course, among other things, it doesn't mean it means we can't be using large-scale achievement tests, which aren't appropriate anyway for measuring progress. We have to use some sort of data collection procedure that, like formative evaluation, maybe curriculum-based measurement, that actually we can look at progress, and if we see a child is not making progress, we make a change. And so that's the next major recommendation. When progress reports and other data do not reflect that an annual goal will be met, reconvene the IEP team to determine why and make needed instructional changes and continue to collect data. Now, a couple months ago, I worked, and some of you may have heard her, Julie Weatherly, who's an attorney for school districts. If you ever get a chance to hear Julie, hear her. She's great. She and I did a webinar for the Council for Exceptional Children. One of the things that we both agree on real clearly is that if you see that a child is making progress, you've got to do something about it. And in the webinar, one of the things Julie quoted another attorney, and I forget her name, works for Galagos in the Galagos law firm, Walsh Galagos law firm, which is another exclusively special ed outfit out of Texas, that says when she gets a FAPE case, the first thing she does is she gets the IEP team and she says, okay, show me the data that shows progress, that shows that you are making progress. And if they don't have the data, she says, settle. Because we can't show progress. You might as well settle right now, because you're not going to win. So very important that you always keep, it's like Well, you know, you measure educational health or physical health. I know I've been having a problem with my knee, so I go into the doctor to talk about a knee. What do you suppose the first thing he does? Puts me on the scale, takes my blood pressure. Why? That has nothing to do with my knee, but he has a baseline of my physical health, and he can tell if something's going awry. Well, if we have a baseline measure of a child's educational health, their ability to read, and we keep our eye on these baseline measures, we can say, well, the child needs some changes, we can make them. So in a way, we're measuring a child's educational health and making those instructional changes when needed, which means we also must collect data. Now, remember this is the standard. A substantive standard not focused on student progress will do little to remedy the pervasive and tragic academic stagnation that prompted Congress to act. The new standard is progress, and that's going to have to be reflected in all aspects of the IEP. This is a hugely important decision. It really changes so much in special ed, but if we're doing the things we're supposed to be doing, like writing measurable goals that are ambitious, collecting data for progress, we don't have to worry about anything. We're doing what we need to be doing. If we're collaborating with parents in a meaningful way, we're doing what we need to be doing. It's when those things aren't happening, that's when this decision is going to be really important. Because again, Supreme Court said the school officials will be called upon to give cogent and reasonable explanations about the goals they chose. Did they allow the child to progress or not? Now, this is, like I said, it's an extremely important case, but there's a really cool website on the internet. All you have to do is go to Google and write SCOTUS blog, Endrew. Just those SCOTUS blog, SEOTUS blog, and Endrew, and you will get to the official United States Supreme Court blog and every bit of information they have gathered on the Endrew case. Now, you can't see it, and I don't think I can actually get to it on this. I don't know if we have internet. Yeah, I think we have internet connection. But I'm going to, anyway, if you go to it, you can find the actual opinion of the court, and I'd urge you to read it. It's, like I said, Justice Roberts is a great writer. It really explains things real well. And you can also find proceedings and orders by the courts. And what's really cool about this site is whenever the Supreme Court hears a case, it asks for what are called amicus briefs or friend of the court briefs. There are briefs had been filed by the Department of Education. There's briefs by the Autism Society that are just really interesting reading. But the most interesting reading of all is the Supreme Court always asks for a brief from the United States Solicitor General. And that is the attorney for the United States. Well, if you think about it, this was under the Obama administration. The Attorney General was very pro-special education and wrote a really great synopsis of everything we've been talking about here today. If you go, it's like down here, but it's called the amicus brief from the Solicitor General. Really interesting reading. Really helps explain what this is. One thing this does not include, maybe it does now, is the question and answer document from the U.S. Department of Education. Go into Google and get that, read it. It's fascinating, and it has what the U.S. Department of Education did is they said, here are 20 important questions that school districts need to understand about this decision. And then after posing the questions, they answer them. Really interesting reading. Helps you understand what the implications of this case is. And then this one is a great website. It's called oye.com. If any of you are legal nerds like myself, before the Supreme Court meets, and it's a really interesting thing, at 10 o'clock when they meet, there's this beautiful big desk course, there'll never be pictures at the Supreme Court because it's illegal to take pictures during sessions. But there's this beautiful long desk where all the justices sit, and there's these big kind of lavender robes, and a guy comes out and says, oyez, all those with business before this honorable court, please come forth, and gives this, and there's this dong, dong, bong, and all the curtains open and the justices step out and sit down, and they start the oral arguments. They have an hour. At the end of the hour, it's over. And they had three arguers in this case. They had the Solicitor General, the arguer for the Douglas County School District, and the person who argued for the parents. So they each had 20 minutes, and then right away questions. The Supreme Court justices start peppering the attorneys with questions. So they prepare for 30-minute presentation. They usually get through about a minute, and they start getting questions, and they have to be able to think on their feet pretty well, because the rule is when the Supreme Court justice says something, you don't say anything, you just listen and answer it. And the OIA site has recordings, because one thing the Supreme Court can do is they can record, and so this has decisions back to the 1960s, and eventually may have decisions back to the 50s. I mean, eventually Brown v. Board may be on here, so if you want to listen to the oral arguments, you can. But, and see how long this takes up. But if you go to the OIA site, and they're right down here, right down here it says oral arguments, and if you press on that site, and let me just get out of this first. Well, I guess I'll just have to wait. But what happens is you get the oral argument of the decision. What is really neat about this is when you press on it, you get to a new page that that has all the pictures of the justices up, and it has the transcripts, but you press the oral, and what it'll say, go to Justice Roberts saying, today we're deciding the case of Andrew F., and the little light up, Justice Roberts' face is lit up, and you can hear what he said. And then they go about 10 minutes in the argument, and Ruth Bader Ginsburg starts asks a question, so it goes to Ruth, the picture lights up for Ruth Bader Ginsburg. But at any rate, it's very interesting. If you ever get a chance to go to the Supreme Court, you really should. They have a thing called a rush line, that if you stand in line for a few minutes, they'll let you go in for 5 minutes and listen and out. It's a fascinating experience. And if you're ever there, like I said, go to the museum and listen to that. So we have just a few minutes left. So what I thought I'd do is take any questions or comments or anything you want to talk about in terms of the Endrew decision.
You see that? There you go.
Well, that is a very good question. And what I would say to that is you put your finger right on it. The key is the data. If you have the data, and the parent disagrees with it, well, you have to listen to them. You have to talk about it. But if you have the data that backs up your position, use that data. Go with that data. Because, I mean, as the experts, courts are not really, they don't want to overturn what the experts say. They're only going to overturn us if we make mistakes. And if we have data that shows this is where the child is, I'm thinking that very few people would take that to court. Again, though, the data is the key. And in terms of present level, it's also having all that info, addressing all needs. Because one thing the idea says is we have to address all needs. Doesn't matter what the child's disability is. If it's a need, we have to address it. So my answer to you is no, not if we have the data. Yeah, it's very possible. I mean, the 10th Circuit, if you read that decision, which is also on the SCOTUS blog, by the way, one of the things you'll know is they say, we don't endorse what Douglas County School did. We don't think they did a very good job, but we think they did just enough. And so if they had not made that, I think eventually, because we had a difference in circuits, they would have eventually been forced to choose something to answer that question, because the circuits were, as the Solicitor General said, the circuits are just so apart from each other. But if you're right, if they had not done it, might still be standing right now. That's a very good point. It's interesting. Yeah, and I mean, there's for some students, I mean, that have a disability that causes physical and mental decline. I mean, how do you show progress? Well, it's in light of the child's individual circumstances. The court pointed that out very carefully because, yeah, for some students, and the court says this, those with more severe disabilities, clearly the progress is not going to be what it is. But nonetheless, we have to consider what is that individual child's potential. And again, if we have the data that shows that, well, we can't expect a great deal of growth, you know, then we make a projection based on what we think the potential for growth is. But remember, according to the courts, we can't err on the side of being too ambitious. The way we err is not being ambitious enough in writing our goals. In fact, I reviewed a case not 3 years ago, last year, that showed us, it was before this decision, but it was essentially that. The private school was saying, we have data to show this and that. Well, their data was really kind of bogus sort of data. And the school district essentially brought that up in their argument. And so they argued that point, that was not legitimate data they were using. And the hearing officer whose decision I was reviewing accepted that. So again, courts are not, they don't want to overturn the decisions of educators, because why? They view educators as the experts. They're not the experts in education. But when it comes down to expert v. expert, which it often does, you know, they're just go, what is the they will call in experts to say what is real in this situation. But I would say your point is really well taken. Sometimes, and a lot of times, there is data that's not good. One of the things courts will do, in the Carter case they did this, is they hired an outside psychologist to come in and collect their own data that was then used by the court to make the determination, because he didn't honestly trust either the Triton Academy or the school district. Okay, are there any other? Okay, thank you very much.